Buster needs out. Hey guys. It's been so long, not since Alive, but since Alive about Britney. And I happened to go on to, actually Steph reminded me, she said something about Noted Your Honor, and I was like, I bet Noted Your Honor on Twitter has the documents from Britney Spears' most recent filings. And so I went on to peruse them, and there's been some updates. Sophia? This child of mine. Okay, so I went on to Noted Your Honor to get our most recent current Britney Spears updates in her conservatorship battle. As we know, actually last week or this week, I think it was last week, was a year since Britney Spears first spoke out in the court case involving her conservatorship. I think it was June 23rd, 2021, when that audio went public and she spoke to an open court, which ended up getting broadcast and then later cut off. But we got to hear from her words, from her mouth, in her words, for the first time about the conservatorship, which in a lot of ways I think was the impetus for her getting new counsel, the world stepping up and helping her, celebrities, whomever, right? Getting the ball rolling to get the conservatorship ended. The conservatorship was officially ended late last year, late 2021, but the counsel that she has, Matthew Rosengart and Greenberg Traurig out of LA, very good litigation counsel, knew that terminating the conservatorship would be one step. The next step would be restoring Britney and her assets after the conservator and related parties took money from her, and to see whether any money was wrongfully placed in other hands. We'll call it that. Yeah, we're going to go over what's going on with Britney Spears. So, since that time, since we last spoke, James Spears, I mean, there's been a lot of things that have happened. Jamie Lynn Spears wrote a book. Britney got pissed. Britney got married. Her ex-husband crashed her wedding. Like, all kinds of things have happened in the world of Britney Spears. But I'm only going to go over the legal stuff. So, the Mr. Spears, Jamie Spears, retained new counsel. Vivian Thoreen is no longer Jamie Spears' counsel, though she was for a very long time, and over a decade, I think. He got this guy named Alex Weingarten. I think I've done some videos or some lives. You can check out my TikTok or my YouTube channel. But he is a spitfire, got in a verbal argument with Matthew Rosengart at a hearing, I think it was in January, about the ability of Jamie Spears to produce documents, etc. So, more recently, well, since October, Rosengart has been attempting to set the deposition of Jamie Spears. Served Vivian Thoreen in October with a notice of deposition, which is how we depose somebody. We have to give them notice. And Vivian said, hey, yo, I'm out. No, he's getting his own counsel. I think my personal feeling on that is likely that had to happen because the way Rosengart was prosecuting this case, Vivian Thoreen was going to find herself in a conflict of interest very fast representing Jamie Spears because she and or her law firm could be up for some disgorgement of fees, but that's neither here nor there. So Jamie Spears gets another attorney, Alex Weingarten, and Rosengart again says, hey, we'd really like to set his deposition. aside from the fact that we need to have access to all of the documents, we need to know things that he knows. We need to know how this happened. We need to know, we need important information about this. We need to set his deposition, which is normal. He is a party here. He is a conservator. The same way he was able to approve all of those accountings and expenditures and money and pay things, it's the same authority that he has to be able to sit for the deposition. It's the same thing. It's the same thing. So, no response. In fact, let me pull up Rosengart's motion, his declaration to compel Jamie Spears to sit for a deposition. So the first deposition notice was October 1. And he agreed to extend a professional courtesy to Vivian Thoreen, who is no longer going to represent Jamie, on October 15th. On November 3rd of 2021, Mr. Spears was served with an amended notice of deposition, noticing the deposition for November 10th. He did not show up for his deposition at that time. On March 2nd, after his counsel failed to offer any alternative dates, he was served with a second amended notice. So we got the original notice, the first amended notice, and then the second. You don't know Britney. How would you know? These are public court records, and I'm a lawyer. I don't know Britney, and I don't know Matthew Rosengart. I'm just breaking down public court documents. You're free to do it on your own as well. Don't feel like you need to stay here. If your phone has somehow attached itself to you and will not get off of my TikTok page, I feel for you. I can only imagine the imposition that is. Perhaps try the turning off button. I don't know what else to say. You know what I mean? So, I'm also a little bit sassy today. Slight bit sassy today. Slight bit. It's been a couple days. You know what I mean? So, anyway. So the second amended deposition notice was accompanied by a cover letter advising Mr. Spears' counsel that despite ample notice with which Mr. Spears has been provided, if you or your client have actual conflicts on that day, we will be amenable to rescheduling the deposition in early April. So it was setting it for April 6th, I believe. Yeah. The deposition was for April 6th. It was served on March 2nd. So ample time notice, and this is generally a good practice that we have in litigation, which is we're going to go ahead and set the deposition date, especially if parties haven't been communicative or there hasn't been a specific date that anybody can agree to and people just need to get it on calendar. Hey, listen, I'm going to go ahead and set it for April 6th. We attach a cover letter that says, hey, if you're not able to make it on April 6th, understood, let's give me notice and then we'll reset it for a date that's mutually convenient for all parties and all counsel. Talking about Britney Spears, thank you for asking. Mr. Spears' counsel failed to respond with any alternative dates in April or for any other time. So rather than providing additional dates, on April 1st, Mr. Spears served objections to the second amended deposition notice, including an objection to the location on the grounds that Mr. Spears resides in Louisiana. Rosengart was attempting to take the deposition in Los Angeles. So later that month, Rosengart sent a letter to Weingarten documenting that Britney had been attempting to take this deposition since October, which is true, and asking to confirm a date. Listen, we get it, understood. When then? If not now, then when? The April 26th, 2022 letter set forth 8 proposed dates. So he's, Rosengart saying, listen, we've attempted to get this on schedule since October. You've continued to put us off. Jamie Spears has rescheduled, no-showed, now objected. And the sole objection, it sounds like, was based on the location. It proposed June 3rd, 7th, 8th, 9th, 10th, 14th, 15th, or 16th, which is important. I wondered what the proposed dates were, because this is getting really far. It's getting much later than the original proposed date, which is October, and very close to the June 27th trial date, or what I anticipate is going to be a trial date on, not June, July. Having not heard back by email dated May 2nd, I again documented Mr. Spears has been avoiding his deposition since October, and again requested that counsel select one of the 8 dates I had previously proposed. So that goes out on April 26th. We're talking about June dates for deposition. April 26th and then May 2nd. He's been avoiding it. Please just select a date. I also agreed to take the deposition in Louisiana or any city in the country with a suitable facility for a deposition. And then he attaches the May 2nd email. A May 4th response came back from Weingarten, but rather than agreeing to any of the 8 proposed deposition dates or proposing any alternative dates, he sought to extract conditions before the deposition could occur. Now, what's disappointing to me about Rosengart is he didn't attach the May 4th letter. He's a smart guy. I assume there's a reason, but I want to know what the conditions are that Jamie Spears required in order to sit for his deposition. What I anticipate it is that Britney would have to sit for her deposition either before or immediately thereafter, because that was a condition precedent that they had required late last year when the depositions were getting set. Jamie Spears was like, listen, I'll sit for your deposition, but Britney's needs to be taken within the next 48 hours after I sit for mine. Oh, I know. I'm sorry, Steph. I'm only disappointed because I want to know what this May 4th letter says. Then there was additional documents and correspondence. And then he actually attaches a letter to TriStar requesting the production of documents and information. And then he attaches the articles from the New York Times about Britney feeling trapped and her business manager benefiting, and the surveillance apparatus that surrounded Britney Spears that was published in September of 21. So that's the declaration. What a declaration is with regard to a motion is like the facts as laid out by the attorney, because they have to sign it under a penalty of perjury. It's the evidence that is submitted to the court in order to decide the motion. So the motion itself is law and argument. The declaration is the facts. What's interesting, and what I haven't yet read through, is that Jamie Spears then files his own motion to compel Britney's deposition. And this is something, I guess it's pretty recent. It was just filed 12 days ago. So Jamie Spears now is going, well, I want to compel Britney's deposition. Rosengart has set his motions for the July 27th date that all of these hearings are going to be heard. I'm not quite sure why, because again, my understanding from reading the transcript with the court for Britney's hearing, the last hearing where they set the July 27th date, was that date was going to be treated as trial for all intents and purposes, which means that discovery needs to be completed by that date, which means you can't have a pending discovery motion be heard on that date because you would have already wanted to take the deposition and have evidence ready for that hearing. So what I'm gathering from this is we're not going to get the finality from that July 27th hearing that we anticipated. But that being neither here nor there, Jamie Spears' notice of motion to compel deposition of Britney Jean Spears, memorandum of points and authorities and support. I usually like to first look at the declaration to see what the evidence is that they're going to be providing to show, hey, look, we're trying to get Britney to sit for a deposition, similar to what Rosengart's doing. Wilkie, let's see. Alex Weingarten is a member of the State Bar of California and a partner at Wilkie, Farr, and Gallagher, known as Wilkie in here. That sounds interesting. He's going to submit this declaration in support of the motion to compel the deposition, and hear his, firsthand knowledge and information with regard to this. There is good cause for granting Jamie's motion to compel. Britney's counsel has refused to provide dates for Britney's deposition. That's, I think, going back to what we were just talking about, I think this is the requirements that Jamie Spears' counsel set forth before that he needed fulfilled before he was going to allow Jamie to sit for a deposition. I think this is that. And it has also stated that Britney will not sit for a deposition. Britney is a party in these proceedings, and her testimony is relevant to various issues to be adjudicated in this matter, including Britney's objections to Jamie's pending petition, and is properly within the scope of discovery under California law, which is the California law discovery statute says in order for it to be discoverable, it needs to be reasonably related to, why am I going to draw? I knew I was going to draw a blank. I thought about it. Reasonably related to the discovery of admissible evidence, I think that's what it's called. Reasonably related to the discovery of admissible evidence. Reasonably calculated to lead to the discovery of admissible evidence. I was so close. That's generally the statute that we pull from to determine whether or not something's discoverable, i.e. whether or not it needs to be exchanged or a deposition provided, things like that. Britney's counsel claims Britney is exempt from discovery obligations regarding her allegations of wrongdoing, but Jamie has a right to prepare his case and depose Britney as she is the individual making unsupported claims against him. What's important to note is this is a civil matter, not criminal, so the right to confront the accused is not there. And it wasn't just Britney who was making these allegations, but people on Britney's behalf. I'm not aware, other than Britney's personal statement to the court, which is not evidence because I don't believe she was sworn in. I'm not aware of a statement made by Britney, so that's an interesting take. Jamie's extensive record production. He was represented by lawyers at Freeman and Smiley, and Holland and Knight prior to Wilkie entering the case. Jamie Spears, obviously. Wilkie received several electronic productions of documents from Freeman and Smiley. I'm going to try to close this. Okay. Between October 18th and November 17th. These productions consisted of approximately 120,000 documents, totaling approximately 570,000 pages. I'm rounding. These productions were concurrently made available to Justin Gold, counsel for John Zabel, who was the temporary conservator of Britney's estate. Remember, that was a very short period of time. He was a conservator of the estate just to wrap it up, and Justin Gold represented him in that matter. In the same manner in which the productions were provided to Wilkie, Freeman also provided approximately 58 boxes of paper records to Gold. Wilkie received 2 electronic productions of documents from Holland and Knight between October 29th and November 2nd. The production of documents Wilkie received from Holland and Knight consisted of approximately 5,000 documents, totaling about 24,000 pages. These 2 productions were concurrently made available to Gold in the same manner in which the productions were provided to Wilkie. Hold on. Interesting that they were made available to Justin Gold, but provided to Wilkie. I don't know if that's just me catching on to like a slight difference in verbiage, or if there was an active provision to Wilkie and like, hey, come pick these up if you can figure out how to load 60,000 boxes in 20 minutes. Like, I don't know if that's, I don't know. Freeman and Holland and Knight collectively produced approximately 125,000 electronic documents, totaling approximately 590,000 pages and approximately 58 boxes of paper records. My understanding, remember, this is Jamie Spears' attorney speaking. My understanding is that all of the documents Freeman and Holland collectively produced to Gold were made available to counsel for Britney Spears in the same format in which the documents were made available to Wilkie. Additionally, neither I nor anyone at Wilkie who represents Jamie reviewed the productions from Freeman or Holland and Knight prior to those productions being made available to Gold or Weingarten. 2, requested that any documents that were produced be withheld from documents made available to Britney's counsel. Or 3, altered or modified in any way the document productions made by Freeman or Holland prior to the documents being made available to Britney's counsel. In short, the exact same documents produced by Freeman and Holland to Gold have been made available to Britney's counsel in the exact same format in which the documents were received by Gold and by Wilkie. Okay, so Britney's temporary conservator of the estate got these documents in the same way I got these documents, and it's our understanding these documents were also made available to Rosengart in the exact same manner for Britney. Okay, that's important. And I'll tell you why in a second. It appears to me the electronic productions I received are bait stamped, meaning there's numbers at the bottom, so there's a total number and you can always reference back. Roughly 30,000 emails between Jamie and his counsel were produced to Britney as part of the production. Now, what's interesting in that that was under the heading Jamie's extensive record production. He's claiming that the productions provided by Holland and Knight and Freeman and Smiley, which used to be and were for an extended period of time Jamie's attorneys, for his role as conservator of the person and estate of Britney Spears. So he's claiming, Mr. Weingarten, Jamie's counsel, is claiming, hey, Jamie Spears' prior attorneys already dumped all of these documents and we didn't ask them to withhold anything. We didn't alter anything. We didn't change the manner in which they were delivered to us versus them. Like, we've done our job. But that's, in my opinion, an intellectually dishonest view, because Jamie holds the responsibility and can't delegate the responsibility that he holds as conservator to his prior attorneys. His prior attorneys, apparently without his input, knowledge, information, or help, disseminate that information, transfer it to Rosengart, and Jamie's attorney concurrently, right? So they're both getting it at the same time, and Jamie's like, yeah, well, I guess the job's done. Okay. What about your job of discovering you have a duty to provide. Like, the conservatorship is over and you've been asked to, one, provide information, and two, it's your duty to give these documents over. Okay, so let me see. There's a question. I'd love to know too. I thought it was all over. Yeah, the Britney update is about the fact that her father, there's a hearing set for July 27th. So I knew that there was going to be some documents that were going to be dropping here pretty quick, and they did. Essentially what's going on right now, just a quick update, is Britney is attempting still to get her dad to sit for deposition, which he has not yet done, and answer discovery, which I also don't think he has done. But in return, her father is now compelling Britney to sit for a deposition. And so what I'm going through right now is Jamie Spears' motion and evidence regarding his attempt to have Britney sit for a deposition for Jamie. So they, Jamie's attorney is alleging that only Britney knows about the allegations that she has made, and that Jamie deserves the opportunity to form a case against those allegations, and in doing so must have Britney made available to him to try to depose her, to try to elicit information in order for him to build his case. I hope that explained it. Baby Dioza, the mascara that I use is an affiliate link, but I think it's like $7. It's listed in my bio. It's easier to say that now. So the link tree in my bio. I'm truly an influencer over here. Has anyone started drinking yet? Water and coffee. So the parties meet and confer regarding, Jamie's request to schedule depositions and confirm scheduling by stipulation. Attached here too as Exhibit 1 is a true and correct copy. Ooh, the email that no, it's not. A true and correct copy of an email I sent to Matthew Rosengart on January 26th, and the letter I received from him as Exhibit 2 on March 22nd. Let me see if I can scroll down to those real quick. Alex said, Counsel, so this was in January, we write to advise that we intend to depose your client and would like to discuss a mutually agreeable date to conduct the deposition. Of course, we will also be discussing the scheduling of Mr. Spears' deposition with you, and will work with you to find a mutually agreeable date for that to proceed as well. Further, we will agree, and this is exactly what I thought happened, we will agree that Mr. Spears can be deposed first. Ideally, we will conduct these depositions in early March, with them occurring either on consecutive days or at least the same week. We'll let you depose our client. We're not stopping you. But in order to do that, we're going to need you to have Britney Spears sit for a deposition like real soon thereafter. Real soon. Additionally, so as to avoid any issues or problems, we propose that we formalize the schedule through a stipulation and court order so that we are all under a court order to appear for the depositions as noticed. Please advise when we can meet and confer regarding this matter, or if the proposal above is acceptable, propose dates that work for you and your client to proceed with both depositions. Additionally, please advise if you are authorized to accept service of a subpoena on behalf of Shireen Abadi. That's a different issue. If we have not heard from you regarding these matters by close of business on Friday, February 4th, we will proceed unilaterally, which means that they're just going to set the deposition. Exhibit 2 is Matthew Rosengart's response. Your efforts to harass, abuse, and bully Britney Spears are ill-advised and will not be... Oh, Jesus, he used a word. Countenanced. Whatever the fuck that means. I've never used that in a sentence. It has been our honor to represent Britney and to protect her from the type of trauma and abuse she testified about in regard to the conservatorship led by your client, who, as you know, after acting as conservator and taking at least $6.3 million from our client's estate in fees and commissions, was suspended by the court on September 29th. We seek to continue to protect our client from further trauma and abuse. In that regard, we view your request to take our client's deposition and your side's apparent tactic of leaking to tabloids your January 26th email expressing your purported interest in asking her questions concerning child safety and possible drug use. It's interesting, I did not see that leak. To be improper and abusive. Those leaks also lend credence to troubling reports we have received concerning your side's apparent disclosure to third parties of confidential medical information, including information that would be violative of HIPAA and CMIA, California Medical Information Act. Any such disclosures must cease and desist immediately. While the deposition of James Spears is warranted, indeed necessary, there is no legitimate good faith basis for taking the deposition of Britney Spears. To the contrary, your client's stated intention to take our client's deposition is, in our view and under the law, but another tactic to bully, harass, and intimidate his daughter, his own daughter. As we've stated, these tactics you have employed on your client's behalf are not, in our view, what a father who loves his daughter should or would do. Instead, he should recognize what his daughter has endured, that she has felt traumatized and abused by him, and he should move on. Even if he disagrees with his daughter's strongly held views and testimony, and even if he disagrees with the New York Times reporting of his conflicts of interest and other improper conduct, your client should simply fulfill his ministerial duties of transferring the files and preparing the final accounting, and then move on. This is a matter of law and fundamental decency. You and your client have professed to the media that he loves his daughter, that he has Britney's best interest at heart, and he wants to protect her. If true, then you should act that way, like a father, and in any event, a fiduciary should. Mr. Spears this is Rosengart's response again to Jamie Spears' attorney. Mr. Spears has had several law firms over the past decade who have employed different approaches, but we have hoped that Wilkie would act with grace and decency towards Britney. Your February 22nd letter and conduct sadly does not fulfill that wish and will only create even more litigation, drive up attorney's fees, which you and your firm will not be able to recover under basic principles of law. Hey dude, if Jamie's not paying his bills to you, just an FYI, you're not going to get it from this pot either. And seek to intimidate our client. Indeed, outrageously and baselessly threatening my law firm and me with civil liberty and disciplinary consequences or criminal liability in connection with your efforts to collect legal fees from Britney Spears was transparently desperate and, more importantly, crossed a major line contrary to proprietary and the rules of professional conduct. Your threats really do not merit a response, but we of course reject them, and as you know, consistent with fundamental legal principles and as set forth in our January 14th filing, we are vigorously contesting your December 15th, 2021 petition for legal fees, which illogically, immorally, and contrary to the law seek payment to you of legal fees from Britney Spears. Then he goes through the legal basis for that. We hope it stops, and in view of the above, we note disappointingly that we have read that you have previously been accused of bullying other people, including women. We have read, Jesus, why would this guy attach this letter to his own motion? We have read in the recent lawsuit filed against you for sexual harassment. This is to the attorney. Marjan Rabbi v. Alex Weingarten et al., that your former legal secretary, Miss Rabbi, referred to as the known office bully who became worse when he faced the pressures of performing as a partner at an international law firm. Miss Rabbi also alleges that you yelled at her, asserting that she was useless to him and like a child, that you ultimately drove her from your desk after deciding that you deserved a young, attractive secretary, and that you would engage in rage-filled, humiliating tantrums directed at women who worked for you. Wow. Indeed, her complaint further alleges, with specificity, that on one occasion when she tried to warn you that you had an apparent problem with a client that you needed to deal with, your response was to tell her, "Fuck off, I'm on vacation." Oh my God. Oh my God. Oh my God. Additionally, her complaint alleges that this type of conduct occurred before, noting that you and your firm were previously sued for discrimination against a woman, alleging wrongful discrimination on the basis of disability, intentional infliction of emotional distress, and hostile work environment. We are not sanguine that our overtures for a more decent approach and potential resolution will be met. Instead, it appears you are intent on driving up legal fees and a very large receivable that you falsely hope Britney will pay as if she were your ATM. We therefore note again, as you must know, under well-established principles of law, the legal fees incurred by your client in connection with this matter should, and we believe will, have to be borne by your client or your law firm, not by Miss Spears. Yeah, this is still Rosengart's response to Weingarten, dated March 2nd. We nevertheless ask you, your firm, and your client to cease tactics, such as your deposition request and the leak of it, which we believe will only backfire in court and in the court of public opinion before more harm, anguish is caused to our client and more time and money is wasted. Shortly after your law, so this is the next section of the letter that we're reading is regarding Jamie Spears' stonewalling and failure to cooperate. After your law firm entered the case, you orally and in writing professed unconditional cooperation, complete transparency without condition. You promised to complete and organize transfer of files, et cetera, et cetera. Law. Despite your promises, you and your client, evidently in concert with Black Box Security and TriStar Sports and Entertainment, have engaged in stonewalling and obfuscation. By way of illustration only, by email dated November 5th, I propounded the following requests, which, as a fiduciary, your client was obligated but failed to answer. Same ones. What were the total fees taken? Produce all corporate formation documents, all organizational and corporate formation documents for all entities, yada, yada, yada. Let's see. Notwithstanding the above, as well as former FBI Special Agent Sharina Bodi's further cooperation of the Times reporting, you recently chose to double down on your initial half denial, falsely representing to the court on January 19th that the above referenced acts never happened. So the surveillance, all of that. Consistent with your client's fiduciary duties and as a matter of law, you are required to produce those communications. And they must not only include communications between and amongst your client, Black Box and TriStar, they must also include communications between Mr. Spears and his counsel at the time. To date, although you have sent thousands of pages of disjointed materials to former temporary conservator of the estate, John Zabel, these were in fact improperly unlabeled and highly disorganized document dumps, apparently designed to obfuscate and force Miss Spears to incur legal fees, searching for proverbial needles in haystacks of boilerplate and duplicative documents. In addition to the deficient manner in which those materials were produced, the materials are substantially incomplete. As referenced above, for example, you have failed to produce any communications, not a single email or text message regarding the illicit spying apparatus at issue, which involved both monitoring and capturing Miss Spears' telephonic and other communications and placing a secret listening device in Miss Spears' bedroom. If you contend you have provided these documents, please send us the identifying Bates labels of all such documents no later than March 7th. You have made bizarre and obviously false statements in court that I somehow planted the New York Times front page September 24 story containing the allegations concerning your client's misconduct. In view of the provably false and outrageous assertions, particularly while you were under oath, it is apparent that what you say simply cannot be trusted or believed. Footnote, you have also threatened on behalf of James Spears to file a motion to unseal and release my client's private, medical, and other records. Why would Mr. Spears do so? The only rationale would be to try to embarrass his daughter. His own daughter, in italicized, for his own purported benefit. Even if your client is under the impression that this futile endeavor would somehow help him, and it would not, he should be counseled against it for two primary reasons. It's harassing and indecent. Moreover, the law is clear. Medical and other private records must remain sealed. I'm trying to see if there's any... Your threats against me and my law firm are contrary to ethical rules and obviously unjustified. This is interesting. You threaten both me and my client with civil liability, professional discipline, and criminal liability if you are unable to collect from Britney Spears legal fees that you are incurring on behalf of your client. Interesting. So Matthew Rosengart in court in January, when the matter was brought to the court, Jamie Spears is attempting to have his lawyer now, be paid out of Britney Spears' estate. Hey, I've got an attorney representing me in this matter, and my attorneys have historically been paid for by Britney Spears money, so I'd like to go ahead and continue that. This attorney is going to be sending their bill to where? And in fact, Jamie's attorney attempted at that time to hold a percentage of Britney Spears' money in trust for the future ability to collect attorney's fees from that money. Rosengart was like, no. This is Britney's money. The conservatorship is over. No one needs to withhold money from her. She is an adult, now able to access and control and make her own decisions with regard to her money, her body. At least that makes one of us in this country. All of that, right? So no. We will not be holding money to pay for your legal fees. So in response to that hearing, apparently there was a February 22nd letter that says, specifically exposing desperation, you assert or at least imply that my firm or I may supposedly hide funds, and in effect you claim that I somehow assured you that your legal fees would be paid. Again, this is Rosengart to Weingarten, who represents Jamie Spears. Rosengart represents Britney. Your claims are false and also belied by the record. Such threats are contrary to ethical rules, and in this case, on the facts, shameful. First, as shown above, based on the record and the law, because Mr. Spears' misconduct is squarely at issue and his fiduciary breaches are evident, as a fundamental legal matter, he is not now entitled to legal fees. In other words, he's not going to be able to get this from Britney. This is related to his intentional acts, his choice to walk outside of his ethical obligations. It's directly related to that. It would be like me alleging, there's no good analogy for this, but it doesn't work like that. And I will say Rosengart has shown very clearly, he has stuck with this argument throughout, that Jamie Spears did not act within the confines of his fiduciary duties. That's the basis for the reason for the deposition and the accounting reviews. And Rosengart would like to go all the way back to the beginning. The 6.3 million keeps coming up. Anyway, in contrast to your misconstruction of the record, on December 8th, I accurately stated my belief that money will be available, the words you used, to pay any appropriate bills. As you must know, however, my firm and I are not trustees, nor do we provide guarantees or control to Ms. Spears' finances. In contrast to the 13 years when your client controlled her finances and largely her life, Ms. Spears is now a free woman. She is and has been the decision maker since the conservatorship was terminated. Any suggestible ambiguity was definitely clarified during the January 19th, 2022 hearing when, after extensive argument, the court expressly rejected your request for a reserve. That's when Weingarten said, okay, well, we'll give her money, but let's just keep some back so I can get paid later. Your threats are not only baseless and improper, they are particularly misguided in light of your demonstrably false statements during the January 19th hearing. And he goes on and on. New York Times journalist Liz Day wrote on Twitter, wow, in a bizarre outburst at Britney Spears' hearing today, Jamie's lawyer suggested that our New York Times investigation exposing Jamie and black box surveillance of Britney was planted by Britney's lawyer and said surveillance didn't happen. A few things to note. New York Times had connected with black box whistleblower Alex Lasov before Britney's new lawyer Rosengart even joined her case, and she goes on to say why this isn't true. And he quotes all of that. This is now page 11. The rest of the headings, there is no proper topic about which James Spears would not be entitled to take the deposition of Britney Spears. The only relevant matters pending before the court concerning Mr. Spears are his accountings and your firm's petition to have Britney continue paying his legal bills. No legitimate benefit to be gained by deposition of Britney. In other words, I'm going to give you all of the reasons why you're not going to take the deposition of my client. There's no reason. There's no legal basis. None of her conduct is at issue. None of this makes any difference. And it's not really based off of her allegations that she said in court or under oath. It's based off of it's based off of her attorney's review and his legal strategy, which I guess you could infer to Britney, but regardless, that would be attorney work product anyway. To conclude, we will not offer deposition dates for Britney. Instead, we object to any such deposition as a matter of law. However, even if you disagree with our legal position, you and your client are on record repeatedly pledging that Mr. Spears loves his daughter, that he will always have Britney's best interests at heart, that he wants to support and protect his daughter. If any of that is true, and given his fiduciary legal obligation to elevate his daughter's interests above his own, you and your client should withdraw the deposition request. And scene. Okay, so let me go back up to his declaration. Exhibit 3, meet and confer letter on May 6th. Let me see what that guy says. Exhibit 3, finding Exhibit 3. Where's Exhibit 3? Rosengart. Okay, here we go. No. I'm trying to find it. I think Rosengart attached a bunch of exhibits to his own letter, and as such, and they used the same. Rosengart used Exhibit 1, 2, 3, and so did Weingarten. So trying to scroll through to see where are this is the objections and opposition to James Spears' petition for payment. Jeez. Okay, here we go. Exhibit 3. Oh, he made it bigger. Jamie agrees to sit for a deposition first and attempts to simultaneously schedule Britney's deposition. We received a response from you on March 2nd stating we will not offer deposition dates for Britney. Instead, we object. There is no cognizable legal basis to object to Britney's deposition. Britney is obviously a party to these proceedings. She is pending objections to Jamie's petitions, etc. She filed documents making numerous allegations of improper and wrongful conduct by Jamie. She claims through her court filings, through her social media musings, to know all kinds of information relating to allegations of wrongdoing. Those aren't under oath, obviously, social media posts. Accordingly, Britney either, one, has the knowledge about her allegations that she professes to have in court filings and on social media, or two, has no such knowledge or support and simply believes that she can say whatever she wants in court and on social media, regardless of whether her allegations are true. If that's the issue, why don't you sue her for defamation? And Jamie is entitled to find out what Britney does or does not know relating to her allegations of wrongdoing. And you know this, as you have provided zero authority supporting the preposterous proposition that a party to a lawsuit who makes allegations of wrongdoing can somehow avoid deposition based on apparent disinterest in being deposed. Britney's testimony is highly relevant and is the very core of her conservatorship case. There is no basis to resist Britney's deposition. There's extremely high bar, which Britney bears the burden to prove to avoid a deposition. I will say avoiding a deposition is extremely hard. I'm going to have to go through and read what Matthew Rosengart's position is and what his legal basis is for refusing Britney's deposition. I would argue initially, how can you depose? If you have maintained over 13 years, Jamie, that she is not aware with it enough, that she is so impaired that she needed a conservatorship of both the person and the estate for the last 13 years. How is she then able to testify as to those 13 years? How is she able, how can she be both an impaired person that needs the conservatorship and aware enough to be able to provide you accurate, under oath testimony with which she could be charged under penalty of perjury for lying or mistruths, right? How can you have both at the same time? Britney is free to participate in the discovery process and pursue her case, but we will not engage in this silly game whereby Britney propounds discovery and expects a response, but then refuses to participate in any discovery. I wonder if they have completely refused. Oh my gosh. So on May 23rd, we're going to have to read this. There was a meet and confer call. What page is this? I have never seen a meet and confer be transcribed, and this is a reporter's transcript of proceedings. Meet and confer call, May 23rd. This is page 114. I'm going to scroll back up and see how he describes this. Transcript from the May 23rd, 2022 meet and confer call. Just 2 days after the parties agreed to continue their discussion regarding Britney and Jamie's deposition, Britney's counsel filed Britney's motion to compel deposition of James Spears. Okay, so let's scroll back down to 114 to see what they talked about. I've never seen this. It's smart because then no one can say, oh, I didn't say that. All right, sounds like we're all on. Who's on the call? They had Alex Weingarten, Eric Bakewell, Sean Hanley, and Emily Horick for Jamie. Greenberg, we should have Rosengart, Lisa McCurdy, Kyle Freeney is joining as well. So everybody's on. As I understand the purpose, Weingarten says, as I understand the purpose of today's call, we're here to talk about the meet and confer letters that we had sent regarding your client's deposition and the request for production of documents that were propounded to your client as well. I'm happy to discuss the Kroll subpoena if you're ready to do that today as well. Otherwise, we have that scheduled for tomorrow. Yeah, they're going to table it. And for purposes, Rosengart says, for purposes of today, we can talk about the discovery that you served. He says, with regard to that discovery, what we have discussed internally and what we will convey to you is that we are going to supplement the written discovery that you served. We believe certain portions of that discovery are objectionable, but just so the record is clear, we are agreeing to supplement that discovery in regard to each set of discovery that you served. I'm not quite sure if it's responses that Britney's providing, or it must be. It must be. So likely what had happened is Rosengart served objections, Britney needs to respond, and there's a meet and confer saying, hey, your objections aren't valid, your client still needs to respond, so Rosengart's going to go ahead and supplement that, fine. Okay, so you're going to supplement your responses to our discovery requests. Can you tell us when you intend to have that done by? And Rosengart says, I think we can probably get it to you within the next few weeks. We're in the process of drafting them right now and looking at documents. We can probably circle back and provide a hard date within 30 days. Weingarten says, okay, well, the statement that I made on our last call about the motion to compel deadline in order for motions to be heard for the July 13th date still stands, and we need to keep things moving. So hopefully it can be mooted, but we still intend to file a motion to compel if we don't have supplemental responses, code compliant supplemental responses, and a production of documents to resolve the issue, yada, 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 which is fine. That's all California law stuff. Because there's a time frame when you serve, you have to abide by. Unless you get the parties to agree to forego that. In this case, that's not going to happen. Rosengart says, we will endeavor to get you our amended written responses before June 16th. We believe we can make progress on this issue. To the extent that we collectively think, and we would need your cooperation in this regard, that it would make sense to push back any motion to compel deadline, we can discuss that at that time. It's probably premature to do it right now, but we think that that would make sense. With regard to the deposition issue, we also think, for the reasons laid out in our letter on March 2nd, that it really makes sense until you get our amended or supplemental responses to wait before addressing that issue. I can just tell you that we obviously take very strong issue with, of course, a number of characterizations in your May 6th letter, including most notably that our client is obligated to, at deposition, respond to questions concerning what you refer to as her allegations. The allegations at issue, which are summarized in our January 14th filing, are not the allegations of Britney Spears. I think it is really important to hit the reset button and discuss context for a second, because your letter does not correctly refer to allegations of misconduct, but it is incorrect, again, that those are the allegations of Britney Spears. The key allegation, or one of the key allegations, concerns whether or not Mr. Spears had knowledge of, was involved in, or directed an illicit surveillance or spying operation on Britney, whether he intercepted or was monitoring or recording texts and other communications, all the stuff that we know about. Those are not allegations contrary to what stated in your letter that were made directly by Britney. Those are allegations that were made by a whistleblower. Relatedly, the allegations at issue in Mr. Spears' conduct include his actual or apparent or potential conflict of interest in violation of California Rule of Court 7.1059. That's not an allegation by Britney. That's an allegation which is factual that we learned, I think he means that we learned about when you confirmed to the New York Times that TriStar loaned money to Jamie Spears. Oh no, which is factual. That we learned when you confirmed to the New York Times that TriStar loaned money to Jamie Spears, and as of the time of the conservatorship, Jamie owed TriStar Sports and Entertainment at least $40,000. We believe that's an actual and apparent conflict of interest. And again, contrary to your meet and confer letter, that is not an allegation made by Britney. It's a fact, but it's not an allegation that comes from her, and therefore not something that should be subjected to a deposition on. Again, I'll circle back and state that we will, in response to your written discovery request, address that issue and several of the others here. Another allegation concerns whether or not Jamie Spears' severe alcoholism affected his administration of the conservatorship. That's something that Jamie Spears is in the best position to testify about. Another allegation concerns how much money Jamie Spears took from the estate. We know he took at least $6.3 million from the estate, according to QuickBooks accounting data that we obtained. That's not something within the knowledge of Britney Spears, who, after all, was in a conservatorship at this time, as we all obviously know. This is just not a classic case of a witness, an ordinary witness having relevant information that he or she should be deposed on, given the unique fact that she was in a conservatorship for 13 years. And again, these are not her allegations. This is not information that she has. Jamie is the one who knows how much money he took. Jamie is the person who knows how much he paid TriStar. Jamie is the person who knows how much he paid Black Box. Jamie is the person who knows whether or not he disclosed the spying operation to the court at the time he submitted the accountings. These are not allegations made by Britney. Jamie is the one who can testify in regard to why he approved the $500,000 payment to TriStar after Britney went on hiatus. Jamie is the one who must and can testify as to why he approved Lou Taylor's personal legal fees in connection with the Brian Kutcher litigation. This is not an allegation made by Britney. That was an accusation initially made in the November 20th, 2020 objections filed by her prior counsel. We can continue down the laundry list, but the point being, we will again be amending our written objections, but it's misplaced in a false premise to say that Britney is making the allegations or has made the allegations that are at the heart of the discovery and that are at the heart of the hearings that are going to occur on July 13th, July 20th, and July 27th, to the extent they go forward. And I think we should have a conversation about that because it's questionable whether they will go forward on that date. Maybe they will, maybe they won't. That's a separate discussion. Another allegation why Jamie spent more than $1 million on expenses on the Louisiana residence, including a substantial amount to his son-in-law's company, not made by Britney. So there's one other thing. Then Weingarten interrupts. Rosengart says, "I'm probably not done, but I'm done for the moment if you want to interject." Okay, so he goes on. The other thing that I was going to say, there's more to say. I'll stop after this. If there's written discovery that has gone back and forth on both sides, we can engage in motion practice on this issue. One thing we want to put on the table, which we think makes sense as a practical matter, would be an informal discovery conference on the written discovery issues before Judge Penny, which is very typical in a matter like this where you've got a ton of discovery. You don't necessarily want to do motion practice or ongoing litigation. You just want to put the issues in front of the judge and go, hey, here's kind of what we're dealing with. How would you rule? Brian is, I don't know if this Brian is her brother. Brian is a brother of hers, but I don't know if that's who they're referencing. Brother-in-law is what we referenced a minute ago. Okay. Weingarten says, "I'm sorry. So I don't believe that Judge Penny has an established IDC procedure, informal discovery conference procedure. If what you're referencing to is having an informal discovery conference in that sense, you're talking about instead of filing motions, asking Judge Penny to convene an informal discovery conference." And Rosengart says, "With regard to the written discovery," and we're not making a commitment to it right now, but I told you I was going to make a proposal on the written discovery, and it's really twofold. We're submitting our supplemental responses. One is we will be submitting our amended and supplemental responses. And two, with regard to this discovery, written discovery, it's something that's going to get very time consuming and expensive on both sides. Our position is that it's very, very clear as a matter of law that you're going to have to pay for Jamie's legal fees. Putting that aside, we just think it makes economic and other sense to, rather than getting bogged down in motion practice or written discovery, have an informal discovery conference. Whether she has a formal procedure or not is something that we believe, based upon experience with the probate court, the judge would be interested in, but we need your cooperation, obviously. Weingarten says, "We'll discuss it and get back to you probably in time for the call tomorrow. I just need to think about it." An alternative to that, which I would want us all to consider, is having a discovery referee and having Judge Penny appoint a discovery referee who can consider all the discovery issues. That's a separate offer that can happen. Sometimes when you go in front of a judge and there's a host of discovery issues, they can appoint a discovery referee. The difference, though, is that a discovery referee gets paid hourly. So the ones that I know get paid $400 to $500 an hour locally to review all of you're still going to have to write motions and engage in a motion practice with regard to all of this discovery. So you're also going to expend the time that you wouldn't have to expend in an informal discovery conference before the judge who would ultimately decide it, and then appear at the confer with the discovery referee. He or she would take all of that under submission and make a decision, and all of that costs you lots of money. So the judge, free. Discovery referee, not. I do think that you raise a valid point about the court's ability to manage what could be many motions to compel, given all the various commitments that the court has in not just this matter, in a very full docket. If you have a response to that now, great. Otherwise, if you want to think about it, Rosengart said it's something that we'll consider. I will just say in response to that, and you're welcome to disagree with this, but this is not your classic commercial case. Certainly not your classic commercial case in which the discovery referee would be appropriate. Discovery referees are expensive. They could engage in protracted discussions and debates without necessarily advancing the ball. This is not a classic commercial case in which there should even be massive discovery disputes. See, called it. There, you pledged in your November 1st, 2021 status report to the court that Mr. Spears has nothing to hide and would hide nothing. You pledged that he encouraged a full, transparent examination of the conservatorship. You pledged, and when I say you, I'm not personalizing it, I'm just saying that your side, on behalf of Mr. Spears, pledged that he would, quote, unconditionally cooperate in transferring all files regarding the estate to Britney's counsel without delay. Let me scroll down. Gene will cooperate. My point being, because he is a fiduciary, this is a unique case. We're not sure why we would need a protracted discovery dispute. And then he goes through the facts. Rosengart repeats himself quite a bit. So there was a lot there. I apologize if I don't hit it all. The notion that the laundry list of allegations that you repeated off the script that you're reading from. Rosengart says, actually, I'm not reading off a script. I'm not reading off a script, by the way. Rosengart says, Counsel, I didn't interrupt you. I did not interrupt you. Even if I disagreed with virtually everything you said, I would appreciate it if you would extend to me the same courtesy. I get in this argument constantly with the opposing counsel. Rosengart says, well, I would say this, Mr. Weingarten. I was purposely, as I have been, reticent and respectful and didn't personalize this at all, as has been your practice in this case. And I'm not going to accept anything else from you. As I was saying, Mr. Weingarten says, the laundry list of allegations that you repeated only then to insist are not being made by your client is betrayed by the fact that your client filed objections to at least my client's fee petition, repeating all of those allegations. So they are indeed allegations that your client is making against my client. They're also statements, for the most part, that you have made to the court directly, or things that you and or your client have said publicly, either to the press or on social media. So I don't agree with the premise. The source of certain allegations might not have originally emanated from your client, but that's immaterial. The fact of the matter is that you filed objections to a pending accounting petition and to our petition, and you are relying on those objections. Indeed, again, on this call, you've made at least 2 references to how my client is not entitled to recovery of attorney's fees under the Shine case because of the allegations that you're making or repeating in your objections. So the notion that they are not allegations your client is making, I think, is a little too cute by half. The fact of the matter is they are allegations that are being made by your client, and they are the basis for the objection she has filed, and they are the basis for things that you have said on this call. So it may be that her answer to those questions about those matters at her deposition is that I don't know, which is fair, or that she doesn't know that she has any basis for those things. Then it will be a very short line of inquiry, yada, yada, yada. In other words, let me break this down. Jamie Spears' attorney wants to depose Britney. Rosengart saying, you have no basis to depose Britney Spears. All of the allegations that we're making are not made based off of Britney Spears' personal knowledge. They're made based off of other, whistleblowers or information that's come up, or, the investigative reporting that has happened. And Rosengart is saying those aren't Britney's allegations, so she has no personal knowledge, so any deposition is going to be moot. She's not going to testify as to any of those things. And Weingarten saying, well, she's using those as the basis to challenge attorney's fees, to challenge fee petitions before the petitions for accounting, approval of accountings before the court. Those allegations comprise a lot of the discussion that she's had on social media about her father. So while she may not be making those allegations, while she may have no personal knowledge of those, we could still depose her on them. And if in her deposition she says, I don't know anything about that, I wasn't there for that, then that's that. I guess the concern for Rosengart, which is generally, to be fair, what would happen in a deposition, they wouldn't just be able to duck out because they have no personal knowledge on specific issues with regard to the entire case. That wouldn't be a basis for not appearing at a deposition, especially when you're a party. And generally at a deposition, the fact that you have no personal knowledge, you could say, I don't know, but hearsay is not a valid objection at a deposition. You could object to hearsay, though most attorneys don't, to provide that on the record, but you would still answer. So what Rosengart could be attempting to intervene with is the idea that Britney would sit for this deposition and get into all of these very intimate details, things that she is very disappointed, upset, traumatized about, and God only knows what her reaction would be. She seems very upset about what's happened. It's freezing. Some bullshit. Sorry. They go on to discuss the documents. Nothing was withheld. I could hear this happening, like them interrupting each other. It's interesting that they're really concerned about interrupting each other, but no one's like, remember, we have a court reporter. We need to make sure that she gets all of this. You guys can't interrupt each other, which is what we do in court and deposition. Weingarten's saying, we produced all the documents that my client has. That production was done many months ago. You served us with blanket objections. We gave you 30-day extensions. Oh, so they didn't respond at all. Britney didn't. I'm not claiming that this is talking about, as far as the notion that this is not a standard commercial civil litigation, I'm not claiming to the contrary that this is a civil litigation. It's a litigation that is unique. There are discovery disputes in probate litigation, and there are occasionally referees that are appointed. There's a whole roster of retired probate judges that specialize in those types of matters. I would love nothing more than to not have to engage in motion practice to resolve these disputes, because I don't think it serves anyone's interest. But the difference is that I haven't been given any choice. I gave you everything we have. You have given me nothing. So this is Jamie's attorney. So absent your commitment and actual execution on that commitment to provide us with responses and actual documents that are code compliant, I don't have a choice in the matter. We're not looking for protracted motion practice. We would like to resolve this. I've asked you many times in writing and in person and on phone calls to have conversations with you to resolve these matters informally. But again, I'm not being given a legitimate alternative. I think the issues are clear. Your client is litigating this dispute. She has filed objections to an accounting petition. She has filed objections to a fee petition. Mr. Rosengart says, of course she has filed objections to your petition. Weingarten says, right. Rosengart says, your petition is not only legally meritless, it's an abomination. So when you say engage in litigation, obviously we have filed objections to your fee petition. It's contrary to law. It's contrary to morality. Again, counsel, I didn't interrupt you. But to address the point that you just raised, well, guess what? Wait. I have to read this verbatim. My apologies. To address the point you just raised, okay, of course you objected. Well, guess what? You stating, of course you objected because of course it's an abomination is not evidence, okay? And so I'm entitled to test the veracity of the allegation that you're making. And thus far, wholly unsubstantiated allegations that you are making through the discovery, and either you have evidence to substantiate those allegations, in which case produce it, or you don't. And to date, you have not only not produced any such evidence, you have told me that you refuse to produce any such evidence. And if that's the case, then I need to file discovery motions to address the issues. So I appreciate your position. I understand what you're saying. It's an abomination. We should all be ashamed of ourselves. It's disgusting. It's disgusting. It's a shonda, whatever you want to call it, okay? I don't agree with any of that, okay? You wouldn't expect me to, and I wouldn't expect you to agree with our position, because if we all agreed with each other, then we wouldn't be having this discussion. Rosengart says, it would be unwise not to take a different perspective and think about what's at issue here, because this is a different case. This is a case in which your client engaged in a corrupted, conflicted, and abusive conservatorship over his daughter. Weingarten says, so prove it. Rosengart says, his own daughter. Weingarten says, so prove it. Rosengart says, excuse me, I didn't interrupt you. Weingarten says, prove it. Rosengart says, I listened to your speech. Weingarten, you absolutely 100% interrupted me. Rosengart says, stop interrupting. What I'm telling you is stop saying that it's corrupt and it's this and it's that. Prove it. Rosengart, I'm not saying. You are saying it. Rosengart, are you finished? Are you finished so I can respond? Counsel, let me know when you're finished. Here's the bottom line. Rosengart says, I patiently listened. You made points. I'd like to respond to them. Counsel, you smoked for almost 30 minutes, uninterrupted. Let me know when you're finished. Okay, the point here is, okay, that you can't just say my client did this and my client did that and he's a bad person who did bad things. Okay? I'm not saying it, Rosengart says. The whistleblower's saying it. And the New York Times is saying it. I'm not saying it. They are. Okay, you interrupted. You are 100% saying it. But even if you weren't, you are relying on the allegations that are being made by others. And so this is the way it works. Stop. Rewind. And so the way this works is that if you are going to either make an allegation or rely on an allegation, you have to substantiate it with evidence. And that's all I'm going to ask you to do. Yeah, I'm grading out. I hear there's a spot open for Mira in Aquaman. Maybe I can audition. I've got blonde hair. They could dye it red. What's the screen time for that actress? If you have evidence to support any of these allegations, you must come forward and produce it. And if you don't, then you have to live with the consequences of that fact. And if I need to get a court order compelling you to produce evidence only to have you say, I don't want it, well, then that's, Rosengart says, you're missing the point. Its own reality. Rosengart says, let me finish. You're missing the point. There's overwhelming evidence of your client's misconduct. He's in possession of that evidence. The question is, to what extent my client, my firm's client, is in possession of the evidence or those facts. So everything you said is based on an incorrect premise. Let me address a couple of the other points. You said that you've produced all documents my client has. Let me just ask, have you produced all of your client's text messages and emails to TriStar, to Blackbox, in between and amongst his counsel at Holland & Knight and Freeman firm? What I was informed by prior counsel, Rosengart says it's a yes or a no. Go ahead. I have told you this several times. I've told you this on this call, and I will tell you again. Okay? Our instruction to prior counsel was to produce everything and withhold nothing. I have been informed. This is like listen, I know it's my duty. I told them to do it. If they didn't do it, I don't know. I have been informed by Freeman and Holland that that's exactly what they did. Rosengart says, Weingarten, my understanding, something. My question is, have you discussed with your client, Jamie Spears, whether or not he has produced all of his text messages between and amongst TriStar, Blackbox, and his counsel? I'm not asking what you were informed. Weingarten says, I have answered your question. I would respectfully, as Heather, disagree. This is also not a meet and confer about what we have or have not produced. I answered this question. Rosengart says, I'm just responding to what you said. I'm just responding to what you said. Let me continue because you went on for 20 minutes. Now I'd like the opportunity to. Weingarten says, no, I went on it was 9 minutes. I timed myself. But let me just say one more thing before you do. The answer to all these issues that you're raising, okay, is to provide amended responses that say, if it's true, okay, and if your client can verify and swear under penalty of perjury that it's true, okay, then in response to the categories of allegations that you're identifying and that upon reasonable search and diligent inquiry, that's all the shit that you have to say when you're required to respond. She has no documents responsive to those requests within her possession, custody, or control, then that's it. That's what the code requires you to provide, and that's what I'm asking you to provide. If she has documents responsive to certain requests, then you identify those documents and you produce them, and that's the response to those requests. It's not a complicated issue. I know, I miss my dramatic readings of court records. It's not. If she doesn't have things that are responsive to a particular category, then the code requires that she provide the response that I just stated. Upon a diligent search and a reasonable inquiry, Ms. Spears has no such documents in her possession, custody, or control. That's it. There's nothing to fight about. You have provided a code-compliant response, and I have no basis to file a motion to compel. That's not the case, and she has responsive documents, then you produce those documents. And that's that. Mr. Rosengart says, let me just go back then, because you spent a lot of time talking about your cooperation. Has your client provided all of his text messages between and amongst Black Box, TriStar, and Counsel? I'm talking about his text messages. And I'm responding now to what you spoke about for your 9 minutes or 15 minutes or however long it was. Have those been produced? Counsel, I've not only answered your question several times on this call, I've also informed you that this call was not supposed to... I don't want to talk about this right now. That's not in the transcript. I'm responding to what you said. Counsel, if you are not satisfied with the responses that we provided to you, then I encourage you to send me a meet and confer letter, and I'm happy to discuss with you what our responses are. Rosengart says, let me ask you something. This is in response to what you said. Counsel, you're now Counsel, let me finish. Weingarten says, Jesus, this poor court reporter. I let you go on for long enough, Counsel. Let me respond. Rosengart says, please don't raise your voice at me, Weingarten says. Jesus Christ. Rosengart says, Counsel. Weingarten says, this is going to be a very short call if you raise your voice to me again. Right. Rosengart says, Counsel, you're welcome to threaten. You're welcome to bully. You're welcome to harass. You're not going to do that to us. Please let me respond. May I? Weingarten says, I am doing no such thing, and you are raising your voice at me. All I was going to say was that if you were dissatisfied with our responses to your written discovery request, then you could have moved to compel. Anyway, I presume that the reason you did not file a motion is because you had no reason to do so. But the fact of the matter is that you served us with 2 separate sets of written discovery requests. We responded, and you did not move to compel on either occasion. With that, the floor is yours. I am going to upload this to YouTube later because I just feel like this dramatic reenactment is what we all needed right now. Rosengart says, you know that's incorrect because we have consistently and repeatedly asked for your cooperation, and I'll just say again, will you produce all texts from Jamie Spears to TriStar, Black Box, and his counsel? You represented that you produced all documents your client has. That's what you said during this call. There's a transcript of it. If that's the case, Weingarten says, well, Rosengart says, no, don't interrupt. Then I'd like the Bates numbers of those documents. You made a point during this call of saying that you produced 135,000 pages of materials. They're disjointed. They're prolix. They're a mess. Will you provide the Bates numbers of the documents reflecting the total fees taken by Jamie Spears? Will you provide the Bates numbers, the page numbers, of the additional information that we sought, not only in discovery, but informally, starting on or about November 5th in my email to you? Will you at least provide, based on your representation, that you produced all documents your client has and the Bates numbers? Will you confirm or deny that he's produced his text messages? I'll take from the silence that you won't. Mr. Weingarten says, I'm sorry, I was waiting for you to finish. I didn't want to interrupt you or be accused of interrupting you, rather. Rosengart says, let me address a couple of other things that you said. Weingarten says, oh, so you don't want me to respond? Rosengart says, you said that. Well, you already responded that stating your position. If you want to change your response, then go ahead. Weingarten says, so this is just rhetorical now? You know what? I'm just going to say. Rosengart says, no, it's not rhetorical. Weingarten says, you're giving a speech. No, I'm not giving a speech. Go ahead and. You don't want me to respond. You already know what I'm going to say. No, I will stop. I will ask the question and stop and then let you answer. Weingarten says, so? Rosengart says, has your client produced all of his text messages? This is the 5th or 6th time he's asked this question. Between and amongst himself, TriStar, Black Box, and Counsel. And if so, please provide us with the Bates labels of those documents. Weingarten, do I have the floor now? Rosengart says, yes, to answer that question. Okay, so to go back to the original purpose of this call, we sent you, see, this is what's so disingenuous is we like to meet and confer with you on what we want to meet and confer with you on. I know that we haven't provided complete, when you play by two sets of ethical rules, allegedly, Rosengart's very matter of fact sticks to what he needs. Weingarten is more move the ball, right? I don't have to answer I can discuss whatever I want to discuss, but I don't have to answer your questions about what you're asking me because that's not why we set up this call. But the purpose of a meet and confer, especially when you have to get a freaking court reporter involved, is to, in good faith, attempt to resolve discovery disputes. And Weingarten is essentially saying, I don't really have to answer yours, but you're going to need to answer mine. And they resolved Weingarten's portion within like 5 pages of this transcript. Rosengart says, I've listened, I've read it. Within 30 days, we're going to go ahead and provide you with updated discovery responses from Britney Spears. The deposition, I don't think we're going to be able to do given these issues. And Rosengart saying, also, did you really provide everything? Because you say you provided everything, but did you? I don't know why Rosengart didn't file a motion to compel he just recently filed the motion to compel Jamie Spears' deposition. But there was no motion to compel with regard to responses of discovery. So I assume he's trying to get that information from other sources like subpoenas to the phone company or subpoenas. I know that there's an outstanding subpoena to TriStar Sports and Entertainment. You have informed us now that you intend to supplement and amend the written discovery responses and that you will endeavor to do so. I responded to that by asking you to please provide your supplemental responses before our deadline to file a motion to compel. Rosengart says, I yield the floor so you could respond to my question, counsel. You're not responding to this is a filibuster. Weingarten says, let me finish what I was saying, please. I've asked you to do that. You said that you would endeavor to do so. You offered to extend the deadline for us to file a motion to compel. I would like to take you up on that and extend that deadline to and including June 16th. Is that acceptable? Rosengart says, it's acceptable. But counsel, I yielded the floor. Thank you. Because you said you would respond to my question. Okay, let me finish, Weingarten says. You have suggested that we will consider asking Judge Penny if she will convene an informal discovery conference. I told you that we would consider that request and we will discuss it tomorrow when we have our scheduled call to discuss the Kroll subpoena. I asked you to consider the appointment of a discovery referee. You said that you would consider it and then we can just discuss that during the Kroll subpoena. I believe that concludes the scheduled purpose of this call, which was to discuss those matters. Rosengart says, so counsel. Mr. Weingarten says, until tomorrow. So you are refusing to respond to answer the question that went to precisely what you raised and spent a lot of time on during the call. The failure to respond, Weingarten says, counsel, I've already responded many times, and I'm not going to. I'm very conscious of the fees that everyone is incurring on this call. I no longer believe this is a productive use of anyone's time. That's why I wanted to summarize what was just discussed. Rosengart says, because you won't respond to a straightforward question that contradicts what you represented during this call. That's it, counsel. Weingarten, counsel, that is completely untrue. Thank you very much for your time, counsel, and we will talk tomorrow. Rosengart says, the record reflects that it is true. Weingarten, thank you, Miss Murphy. Our court reporter. So they must have had a call the following day. Did they not transcribe that one? Because, geez, that would be amazing. He attaches Britney Spears' social media posts. Well, if anybody needs Britney Spears' social media posts, it looks like they're all attached here. Anything else? I'm still at Weingarten. No, damn, 100 pages later. Okay. So that's still of Weingarten's separate statement, or his evidence in support of the motion to compel for the responses of Britney Spears. So they must not have gotten those. Britney's team and Rosengart must not have gotten her further responses to Jamie's counsel in time for the motion to compel, which was filed. Let's see. Okay. Consolidated declaration. Separate statement. Okay, so all the rest of them are just necessary documents. What is happening with Britney? So I just went through some of the documents, the evidentiary documents that are going to be at issue on the 16th. Let me make sure that's the right date. July 13th. I think that's the next date for Britney. We'll see what happens at that point. Essentially, boils down to Rosengart still hasn't received the documents and communications that he deserves per law, according to him, from Jamie Spears, including his text messages between Black Bloc Security, TriStar Sports and Entertainment, and his former attorneys, and any other documents or communication. And he has noticed Jamie Spears' deposition multiple times, and Jamie Spears has still not showed up for that deposition. Additionally, Jamie Spears has been served with discovery requests that two sets, which apparently have been responded to, but motions to compel were not filed, meaning that Rosengart was at least agreeable with the responses enough that he didn't need to file a court motion with regard to those, even though he clearly contends that they were not complete. And Jamie Spears' team is attempting to depose Britney. Rosengart is saying there is zero need to depose Britney. She was in a conservatorship for 13 years. She has no personal knowledge on the facts which form the basis for the allegations that have been lodged against Jamie Spears by numerous individuals, not necessarily her, but that have been used by her team to support the termination of the conservatorship or the allegation or the position with regard to the fees of Jamie Spears not being paid by Britney Spears. So where they stand now is it doesn't sound like either deposition has moved forward. Britney, it doesn't sound like has responded to discovery requests. That's a really tricky situation to put her in, depending on how you answer those. What Rosengart did when he received those is responded just with objections, which happens quite often. The mean confer comes back from Jamie's counsel and says, you need to fix this. You need to respond with actual words and under penalty of perjury. And if she says she doesn't have any evidence to that effect, then she doesn't have any evidence to that effect, any documents or whatever, and you can respond accordingly. But if Britney says anything, then that's going to form the basis of anything substantive, like I was there when Black Box Security searched my bedroom and I was removed from the residence for 30 minutes. Something like that, right? If she says anything like that in her responses, then that's going to form the basis of the request by Jamie Spears' counsel to depose Britney because she will have some personal knowledge, et cetera, et cetera. So we'll see what happens from there. But I wanted to come on here because it's been a heavy week and I thought that this would give us some levity. Britney's out of her conservatorship. This is the fight that continues after that. And it's really, I promise you guys, this is, while I reenacted it very comedically and dramatically, this is every conversation with opposing counsel where counsel does not agree. So realistically, how long can this go on for? A long time. I anticipated that the counsel would be ready for trial by June 27th. Clearly that's not going to happen. Or July 27th. Clearly that's not going to happen. But a long time. A long time. Another year or two. It really depends. But I will let you guys know and keep you guys updated. Your bag collection, I need a full closet tour. Oh my God. You have no idea. That guy right there and that guy right there, they're like, I haven't left the house enough to take them out. But I will. I will do maybe I can do like a lighthearted YouTube live with my bags. Like I'll just take them down and we could talk about them and where I got them and how attached to them I am because it's a 15+ year collection. So, I hope you guys have a good day. I hope you guys are able to stay positive and thank you for joining me for this. And if you're on YouTube, thanks for watching after on the replay. Leave any thoughts or questions in the comment section below. I hear that's what you're supposed to say on YouTube. And I hope you guys all have a wonderful day.